When we think about landmark Supreme Court cases, we usually picture these huge abstract ideas, right? But what if I told you that one of the most important cases you've probably never even heard of all started with a home invasion? Yeah, a smashed-in door. It sparked a question that literally almost tore an entire state apart. So, let's dig into how a simple broken lock spiraled into a massive constitutional crisis. So, this is the central question, really. When you have two different governments both claiming to be in charge of a state, who gets to decide which one is the real one? I mean, it sounds like something straight out of a political thriller, doesn't it? But back in 1842, this was the reality in Rhode Island. You had two governors, two legislatures, two groups, each claiming to be the one true government. And the chaos that came next, well, it forced the Supreme Court to face a question they had never, ever seen before. Okay, so let's set the scene. It's late June in Warren, Rhode Island. A bunch of guys, led by a man named Luther Borden, just break down the door of Martin Luther's house. Now, from their perspective, they're the law. They're state militia agents there to arrest him for insurrection. But Martin Luther, he sees things very differently. To him, they're just criminals, trespassers, acting for a fake government that doesn't exist anymore. He was convinced that the real government was a new one, his government. So what does he do? He sues them. And believe it or not, that one simple lawsuit for trespass is what sent this whole thing spiraling all the way to the Supreme Court. So, to really get how we ended up here, we've got to rewind. And I mean way back. Because the root of this whole conflict, it wasn't some new issue. It was basically a ghost from the colonial era. A nearly 200-year-old document that was, incredibly, still running the entire state. And this is what's so wild about Rhode Island's situation. See, after the American Revolution, pretty much every other state was like, okay, out with the old. They tossed their colonial charters and wrote brand new state constitutions. But not Rhode Island. Nope. They just kind of dusted off their old 1663 royal charter, a piece of paper from King Charles II, and just kept on using it. For more than 60 years after becoming an independent state, this old colonial document was still the law of the land. Just think about that, and you can probably guess this created a massive problem. This charter? It was ancient, totally inflexible, and just deeply undemocratic. For one, under its rules, only men who owned property could vote. That meant a huge and growing number of citizens had no say at all. But here's the real kicker. The charter had no way to be amended. None. There was literally no legal way to change the system. So by 1841, reformers were fed up and decided, okay, if we can't go through it, we'll go around it. They organized their own People's Convention, wrote a whole new constitution that expanded voting rights, and they put it to a vote of the people. Now, the reformers were convinced their new constitution had been approved by a majority of the people. So they started acting like it was the law. And right here, this is the moment the whole political crisis just boils over and becomes a full-blown constitutional meltdown. So, in the spring of 1842, these reformers actually hold elections under their new constitution. They elect a governor, a guy named Thomas Dorr, and a whole legislature. They all get together, take their oaths of office, and just declare themselves the new legitimate government of Rhode Island. Their argument was pretty simple. We have the consent of the people. But of course, the old charter government, the one that still controlled the state house and all the official buildings, they weren't just going to pack up and leave. They didn't see the people's government as legitimate at all. To them, it was a treasonous rebellion, so they refused to recognize Governor Dorr's authority and even passed laws making it a crime to hold office in this new government. And then, the charter government took a really extreme step. On June 25, 1842, seeing that the Dorr government had armed supporters, they declared martial law. Across the entire state, this suspended all ordinary laws and basically put the military in complete control. And it was under this exact declaration of martial law that just 4 days later, the militia smashed in Martin Luther's door. And that brings us right back to the legal battle. See, Martin Luther's lawsuit wasn't really about his broken door. It was a direct challenge to the charter government's very right to exist. And all of a sudden, the Supreme Court found itself facing what looked like an absolutely impossible choice. Luther's legal argument was actually pretty simple, but it was incredibly powerful. He basically said, look, the people's government is the real government because it was approved by a majority of the people. And if that's true, then the old charter government had zero authority, its martial law declaration was illegal, and that means Luther Borden's raid on his house wasn't an act of law enforcement, it was just criminal trespass. Simple as that. So there it is. the Supreme Court has this absolutely explosive question dropped right in its lap. Because think about it, to decide if Borden was a trespasser, the court first had to decide which government was the lawful one. The implications were just staggering. If they sided with the people's government, it would mean that every single law passed and every action taken by the charter government was suddenly null and void, a total mess. So everyone is waiting for the court to pick a winner, right? To point to one government and say, you're the legitimate one, and to the other and say, you're not. But instead, in a decision that would become a landmark, the court did something nobody expected. It refused to answer the question at all. And the absolute core of their ruling is captured right here in this quote from Chief Justice Taney. Writing for the court, he basically said, this isn't our job. He argued that figuring out which government is the legitimate one in a state, well, that's not a legal question for judges to figure out. It is, and I'm quoting here, a question to be settled by the political power. This single decision created one of the most important ideas in all of American law, something called the Political Question Doctrine. You can think of it as a rule of judicial self-restraint. The whole idea is that some questions are just so fundamentally political that the Constitution hands them over to the elected branches, Congress and the president, and not to the courts. So the court basically laid out a clear pecking order. Who gets to decide? Well, step 1, Congress decides when it chooses to seat a state's representatives. Step 2, the president decides when he has to choose which government to support in a crisis. And in this particular case, the president had already thrown his support behind the charter government. So Chief Justice Taney concluded the court's job was simple: follow the lead of the political branches. Don't try to get out ahead of them. So in the end, the court sided with Borden, not because they said his government was the right one, but because they said their hands were tied. They had to follow the decision made by the political branches. Now, this might sound like some dusty old technicality from the 1840s, but the doctrine created in this case, Luther v. Borden, still draws the lines of power in our government to this very day. And believe me, the precedent from this one case is still incredibly powerful. To this day, courts will often refuse to hear cases that touch on a whole range of sensitive issues. For instance, they won't second-guess the president on foreign policy or how he recognizes foreign governments. They won't tell Congress how to run its own internal business. They tend to stay away from messy disputes about deploying troops or how a constitutional amendment gets ratified. They just label them political questions and say, sorry, that's for the other branches to handle. So at its heart, the political question doctrine is really all about respecting the separation of powers. It's designed to keep the courts from getting dragged into political fights they can't win. But it also means that on some of the most fundamental questions we can ask, questions about the very nature of government itself, the final umpire isn't a judge in a black robe. It's the political process. And that leaves us with a really big, critical question. If the courts can't or won't step in, then who holds the political branches accountable? Who makes sure they use that power wisely?